crime in the city, might it decrease with the changes to bail reform in Governor Hochul's new budget?
The agreement removes what is known as the least restrictive means standard, which many judges have said tied their hands.
Joining us, Andrew Lieb, attorney and legal analyst at Lieb at Law PC. Good to have you here. Explain for our listeners, if you would, first, with the previous bail reform, how were judges' hands tied? What were they not allowed to do?
Thanks, Bridget, for having me. Yeah, in 2019, they changed the criminal procedure law to Section 510-10, and they really made it two different things. Number one, you couldn't do monetary bail unless there was a qualifying condition, meaning the right type of crime. And just to give you ideas, like a crime with witness tampering could have monetary bail, or a murder or death of a Class A felony could have monetary bail. But unless that was the case, you couldn't have money charged in the bail. And the second thing, Bridget, that's important is they had this thing called the least restrictive alternative. And they said, hey, the judge had to always take the least restrictive alternative, and the goal being the least restrictive alternative to assure that the defendant, the principal, returned to court. And people were very upset about that because it really tied the judge's hands as they had to follow the rules instead of having full discretion.
Okay, and so now under Hochul's reforms, and by the way, they still have to, cross their T's and dot their I's on this in Albany, but now presumably you would be able to have cash charged when it comes to bail.
I'm not 100% sure about that. Like you said, dot the I's and cross the T's. But Hochul's statement itself said she's going to get rid of the least restrictive means standard. And to be clear, the statute doesn't even call it least restrictive means standard. It calls it least restrictive alternative. And like I mentioned before, the real issue is that the judge cannot give monetary bail on most crimes that aren't in the enumerated list. So I think that it's a start. But what we really need to see if Hochul is going to give judges full discretion, if we think that is the best case, and I'm not saying it is, but if we think it is, then we need to eliminate this qualifying charges and allow judges across the board to decide when monetary bail is appropriate.
All righty. Well, listen, we thank you so much for your insights. We certainly appreciate it. Andrew Lieb, attorney and legal analyst at Lieb at Law PC. Obviously, this is a hot political issue, too, and some people who are opposed to the reforms to bail reform are saying that it would make it difficult for poorer people to ever get out on bail.